Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update on the Delhi Chief Minister Arvind Kejriwal's plea challenging his arrest by the Enforcement Directorate in the Delhi liquor policy case. Kejriwal has approached the top court after his petition was dismissed by the Delhi High Court. While hearing the plea today, the Supreme Court expressed that if the hearing gets delayed, then it might consider the question of interim bail for the purpose of Lok Sabha elections. The bench of Justices Sanjeev Khanna and Dipankar Datta heard the arguments today made by Senior Advocate Dr. Abhishek Manu Singhvi appearing for Kejriwal and Additional Solicitor General S.V. Raju for the Enforcement Directorate. Singhvi said that even though ED sent summons to Kejriwal on 16th March, till then he was not accused. He questioned what was the sudden change that led to his arrest in 15 days, even though ED had no new evidence and was only using documents and statements from the year 2023. Singhvi also challenged that apart from implicating Kejriwal for assisting the formulation of the liquor policy, the Enforcement Directorate also alleged that he was vicariously liable as the chief of the Aam Aadmi Party, to which a part of the proceeds of the crime was allegedly diverted. Singhvi contended that a political party would not come under Section 70 of PMLA, but the bench expressed difficulty in accepting this argument. The Additional Solicitor General S.V. Raju emphasized that there was substantial material involved in the case, rejecting claims of lack of evidence or the use of irrelevant information. He argued that the court's authority to assess whether the arresting officer acted correctly is limited, and it cannot scrutinize the evidence relied upon by the investigating officer. The ASG pointed out that the investigating officer's perspective was supported by the remand orders issued by the special judge and a judgment from the Delhi High Court. The hearing in the matter will continue on Tuesday. Stay tuned. The Jharkhand High Court has delivered the verdict in the plea filed by former State Chief Minister Hemant Soren challenging his arrest by the Enforcement Directorate in the land scam case. His challenge has been dismissed by the bench of Acting Chief Justice Shri Chandrasekhar and Justice Navneet Kumar. As you know, Soren is being investigated for money laundering charges in connection with an illegal mining case as well as an alleged land scam. He has been under custody since his arrest by the Enforcement Directorate in January this year. If you recall, he had moved the Supreme Court, citing the High Court's delay in pronouncing this verdict, as the order was reserved on 28th February by the High Court. 4 days ago, the Apex Court, while posting his plea against ED arrest to May, had stated that it would be open to the High Court to pronounce the judgment in the matter. Also, Soren has been granted interim bail in another petition for 1 day to attend the Shraddh ceremony of his uncle who passed away last month. The Supreme Court has dismissed the SLP filed by the state of Kerala challenging a 2019 judgment of the Kerala High Court. By this judgment, the High Court had directed the state to grant 1 lakh as compensation to a man who was illegally detained by the police on the suspicion of being a Maoist. Back in the year 2014, Shyam Balakrishnan, an author and researcher, was detained by the police on suspicion of being a Maoist. They took him to the police station and he was strip searched. Later, officers of Thunderbolt, which is a special force of the Kerala police to deal with Maoists, also searched his home and seized his books and laptop. All these coercive steps were taken without following the procedure under the Code of Criminal Procedure. Balakrishnan, who happens to be the son of a retired High Court judge, filed a writ petition alleging that the illegal arrest, search and seizure caused him agony and tarnished his reputation and violated his personal liberty and the right to privacy. The High Court had observed that merely on a suspicion that the petitioner has embraced the Maoist ideology, he could not be persecuted by the state authorities. The court also granted compensation, saying that it would be a reminder to the police to be careful when dealing with people's freedom while doing their job. The state, against this judgment, approached the apex court, but the bench of Justices Sudhanshu Dhulia and P.B. Varale dismissed the plea. However, the court has left the question of law open. Hani Babu, a former Delhi University professor, today withdrew his petition in the Supreme Court seeking bail in the Bima Koregaon case over alleged Maoist links. The matter was today heard by the bench of Justices Bela Trivedi and Pankaj Mittal. The counsel appearing for Babu informed the court that there had been a change in circumstances as 5 co-accused in the matter had been granted bail and that they wanted to approach the High Court. Babu has been lodged in jail since July 2020 after being arrested under the UAPA in connection with the 2018 caste-based violence that broke out at Bima Koregaon in Pune. In the year 2022, the Bombay High Court had rejected his bail application, so he approached the apex court. If you remember, last month the Supreme Court had granted bail to Shoma Sen, a co-accused in the case, after observing that there was no prima facie case against her. The Supreme Court today stayed an order passed by the Punjab and Haryana High Court for opening of the road to Punjab Chief Minister's house on experimental basis from 1st May. This road in front of the CM's residence was blocked for security purposes during the Khalistani terrorism of 1980s. Last month, the Punjab and Haryana High Court, while dealing with matters relating to traffic and infrastructure problems in Chandigarh, had called for temporary opening up of the road. It had asked the Director General and Senior Superintendent of Police to make a traffic management plan as to how the traffic congestion could be eased. Challenging this, the state government approached the Supreme Court. The Advocate General of Punjab, Senior Advocate Gurminder Singh, requested the court to stay the direction. He pointed out to the killing of singer Sidhu Moosewala 2 days after his security was scaled down and also referred to a rocket-propelled grenade attack on the intelligence headquarters. The bench of Justices Sanjeev Khanna and Dipankar Datta today stayed the order and said that nobody wants anything untoward to happen. The court issued notice in the petition returnable within 2 weeks. Have you heard of namesake candidates or double candidates in an election? For those of you who do not know, these are individuals who share the same or similar name as another candidate running in an election. They file their nominations just to confuse voters or dilute the vote bank of the genuine candidate with the same name. These namesake candidates often have little to no intention of seriously contesting the election but still appear on the ballot. In this regard, a public interest litigation was filed in the Supreme Court seeking directions to bar such candidates. Directions were sought to the Election Commission of India to scrutinize their background and prevent them from contesting if they have been deliberately fielded by the opponents. The petition was placed before a bench of Justices B.R. Gawai, Satish Chandra Sharma and Sandeep Mehta. The petitioner cited the example of O. Paneerselvam, former Tamil Nadu Chief Minister, who was found competing against 4 other candidates with the same name in the same parliamentary constituency during the Phase 1 polling last month. But the bench was not inclined to entertain the petition. Justice Gawai questioned whether individuals with similar names to prominent figures should be barred from contesting elections. He said, if somebody is born as Rahul Gandhi or if somebody is born as Lalu Prasad Yadav, how will they be prevented from contesting elections? Would it not affect their rights? Since the bench was not convinced to entertain the petition, the counsel requested to withdraw it. We have been updating you regarding the matter where Supreme Court has been displeased with 2 members of National Consumer Disputes Redressal Commission for issuing non-bailable warrants against the directors of a company after they failed to file certain compliance affidavits. This was despite Supreme Court's specific direction to not issue any coercive steps. When the matter was called for hearing today, the bench of Justices Hima Kohli and Ehsanuddin Amanullah was not convinced by the explanation offered by the erring members of NCDRC. The court noted that even after it issued the notice, they did not recall the non-bailable warrants. Being present in the court, the members explained that they were under the impression that they could not withdraw their order once it had been passed. Appearing for their behalf was Attorney General R. Venkataramani, who accepted the fault and submitted that the mistake was not deliberate and also tendered an unconditional apology for the mistake. Unconvinced, the bench today issued contempt notice and asked them to show cause why contempt of court proceedings should not be initiated against them. The bench of Justices B.R. Gawai, Satish Chandra Sharma and Sandeep Mehta today stayed another order of the Punjab and Haryana High Court. Through this order, the High Court had asked the state and the Union Territory of Chandigarh to clear the protesters blocking the Mohali-Chandigarh road, demanding the release of Sikh political prisoners. This order was passed while considering a public interest litigation which alleged that the protest had been going on since January 2023, causing inconvenience to the general public who needed medical facilities and school-going students. The top court today perused the photographs and observed that it was apparent that there was no large gathering. Thus, it issued notice in the petition filed by the state of Punjab against the High Court's order and stayed it. The Delhi High Court today issued notice on the pleas filed by former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia seeking bail in the money laundering and corruption cases connected to the liquor policy case. The single bench of Justice Swarnakant Sharma has issued notices to ED and CBI. Sisodia's counsel, Senior Advocate Dayan Krishnan, requested for continuing the trial court's order allowing him to meet his ailing wife once a week, to which the Enforcement Directorate did not object. Let me tell you, Sisodia's bail pleas were dismissed by the trial court earlier this week, prompting him to approach the Delhi High Court. The trial court cited delays in proceedings partly attributable to Sisodia himself as grounds for denying bail. This denial follows previous refusals from both the Delhi High Court and the Supreme Court, which also dismissed Sisodia's review and curative petitions. Let me also tell you, the Apex Court, while dismissing his bail plea, had last year said that he could file a fresh bail plea if the trial proceeds at a slow pace. And lastly, the Madhya Pradesh High Court has reiterated that as marital rape has not been recognized as an offence in India, any sexual intercourse, including unnatural sex by a man with a wife, will not amount to rape, as the consent of the wife becomes immaterial in such cases. In this case, a complaint was filed by the wife against her husband for engaging in unnatural sexual activity. But the court dismissed the complaint against the husband, ruling that engaging in unnatural sexual activity with one's legally wedded wife is not an offence under the Indian Penal Code. The bench of Justice Gurpal Singh Ahluwalia held if the wife is residing at the residence of the husband during a valid marriage when any sexual intercourse or sexual act by a man with his own wife not below the age of 15 years will not be rape. The court further added that the only exception to this position of law was Section 376B of IPC, where the sexual act with his own wife during the separate living on account of judicial separation or otherwise would be rape. Do comment and let us know about your views on the same. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.